When it comes to dividing debt in a divorce, what do you see as kind of a common problem or something that gets overlooked that can create problems after the divorce is done?
The main problem is
Hello, everyone, and thank you for joining us today. My name is Holly Mullin. I am the managing partner at Sterling Law Offices, and I have with me today special guest, attorney Jeff Morrell. Jeff, thank you very much for joining us again.
happy to be here, as always.
And Jeff is my astute colleague. He is a senior partner at our Appleton office, and he's joined us in the past, and he's been an excellent source of information for our guests for all of our topics related to family law. And we're going to keep on that trend today, talking about debt in divorce, which is not exactly a fun topic, but it is an important one because we see it in essentially every single divorce. We focus our time initially thinking about assets and income, support payments, but we really also need to be thinking about how these debts are going to be paid off or allocated at the time of a divorce. So, how can we make sure we're protecting ourselves when we're looking at life after a divorce and making sure we are thoughtful about handling debts? So, Jeff, when it comes to dividing debt in a divorce, what do you see as kind of a common problem or something that gets overlooked that can create problems after the divorce is done?
The main problem is figuring out ways to divide the debt in a way that makes functional sense. Like when you have a bank account with $1,000 in it, it's really easy to go to the bank and split that account in two. When you're looking at a debt, now we have a third person involved, the creditor. It's you and your spouse and now the creditor, and they don't necessarily want to just split it up, right? They had a contract with you, these big credit card companies, for example, or loan companies or banks don't necessarily make it easy for you to make these kinds of changes.
How can you protect a client when you're coming up with a plan here? How do you protect a client from having a joint account when the lender says we don't want to split it up? We don't want to give half to wife and half to husband.
Yeah, and I would say that that's the norm is a bank's not interested in doing that. So depends on the debt, right? The larger the debt, the bigger the problem. But we're going to use some creative problem solving, moving assets around or moving debts around, seeing what's available to the person who's going to be taking that debt. So like, does that person have access to a credit line or some other way to satisfy the debt such that my client's relieved of it and doesn't have to worry about that person, especially when there's been a history of non-payment of debts. We're always on the lookout for that. That we want to make sure that we're free of that person and their impact on the credit score stops on the day of the divorce.
So in an ideal situation, a joint line of credit is closed out, whether it's because they've paid it off or because one person transferred it into their name alone. But the idea is a goal is you no longer have a joint debt with both parties' name on it.
Definitely. We want to get rid of all of those.
Because what happens in a situation where you didn't do that, right? Like we've seen post-judgment cases, clients come to us and maybe we had nothing to do with their initial divorce, but they come to us after the fact saying, we were supposed to share in this credit card debt. My spouse didn't pay. It's still in my name. Now the creditor, wants me to pay. What's going to happen likely in that situation?
Yeah, it's a major problem because you can't just go to the creditor and say, here's my divorce judgment. Here's my divorce decree, my findings. And it says he's responsible. So get out of here. The bank's going to look at it and say, we didn't sign that. We had nothing to do with it. We had a contract with you and with him, and you owe us now. So pony up. So you can enforce the order, the court's order, the judgment by a contempt action, but it's going to take time, and your credit score is going down in the meantime. It is not fun. When people come to me like he or she isn't paying that debt, I'll say go make the payments on their behalf. We'll file for contempt. We're going to get that money back, but we want to stop the bleeding, the impact to your credit score right now. But hopefully that's not a problem. If you structure it right at the time that you get divorced, you shouldn't have to deal with it though.
It's an excellent point. It's to say, look, I get that you, client, aren't at fault. You aren't the one who was supposed to pay this, but at the end of the day, your credit score is on the line here. And if
it's the worst.
Yeah.
It's the worst. You've done it, Holly, right? You have to tell people, I need you to the credit, we're not going to get to court for a month or two. You got to go make this payment if you care about your credit score.
Because even if your ex is found in contempt and the court says, sir, you were supposed to pay this. I'm holding you in contempt. And you can pay your wife's attorney's fees and you have to reimburse her for all of the payments she advanced on your behalf. The one thing the circuit court and family is not going to be able to do is restore your damaged credit. They can't say,
Right, exactly.
and we're gonna court order, you know, TransUnion.
FICO or
Yeah,
whoever.
they're not
Yeah,
gonna be able to say, now go ahead and boost their credit score back to where it was because this isn't.
that'd be nice.
Yeah, wouldn't that be nice? So there's only so much recourse family court can give us, and the rest it's sort of like protect yourself, and we'll come back in retrospect to try and make you whole. Yeah.
Right.
So when you are drafting a marital settlement agreement to try and avoid this after divorce problem, what can you do during the divorce negotiations, in drafting a settlement that helps to protect clients against this possible problem?
Really, I'm keeping a keen eye out for, does the other person, does my client's spouse have a history of financial irresponsibility? That's first and foremost, because if they do, it becomes really obvious. I'm not really looking for creative solutions. How do I get the debt out of my client's name is all I'm focused on. If they don't, then I'm working with my client to see what their goals are and creating that solution so that we can accomplish as many of their goals while protecting them from anything going wrong in the future if that person becomes unable to pay, refuses to pay, or something along those lines. I've had situations, maybe you have too, with Parent Plus loans for student loans for children, and both parents are on that. There isn't money to satisfy the loan. And so each parent is going to have to pay. Maybe we do alternating years. The best solutions are often like we have a joint bank account. Each person is depositing every month, and there's 3 months maybe of future payments sitting in that account so that if one person fails to pay, there's still money in that account to make the payments pending a hearing or something like that.
Oh, I like that. That's creative. You said you're not thinking creative. That's creative. I like that.
I don't love those. They're messy, right? That I don't doubt that a few people lost me on that because it's not that clean, it's not that clear, and it's complicated, but it's a solution to a problem.
Yeah, especially when you know that there's a history of somebody being irresponsible. I mean, if you have clients who both have 800 credit scores and no one's going to drop the ball, you feel a little bit more comfortable. They're employed, they're going to pay this off. But when you have a credit rat and then you have a client like I'm really worried and you say, well, here's some thoughts. Here's something we could do to maybe dodge a bullet down the road. And I think that's great. You mentioned in a prior episode that you and I talked about debt. You had mentioned to me debt isn't, even though the presumption of debt division is the same as assets, where we presume just like assets, debts are divided equally, that doesn't necessarily mean every debt is cut down the middle with each person taking 50% of that debt. Tell me more about that. What do you mean when you say not every debt gets cut down the middle just because it's considered 50-50?
Right. The same applies to assets, right? If you have a house, you can't cut the house in half. Someone's going to take the house and pay the other person. And so that's most likely what's going to happen with debts also. If you've got a credit card, and usually almost all credit cards, one person's the account holder and the other person's an authorized user. So whoever the account holder is going to take that debt, and then the let's say it's a $10,000 credit card debt, then that $5,000 difference needs to be made up for on the other spouse's side of the spreadsheet or the equation to balance things out.
So it could be you're awarded a majority of the debt because you're awarded the majority of the assets. It's sort of as long as that bottom line comes out to equal how it's
Right. You
accomplished.
can imagine a scenario where a husband has $10,000 in credit card debt, a wife has $10,000 in cash, and both have $50,000 in retirement. Well, the wife is going to give the husband $10,000 and they're going to be equal because they both have just $50,000 in retirement now.
Yep, that makes perfect sense. So talk to me about any sort of special situations with debt where maybe we aren't including it exactly 50-50.
Yeah, so student loans are one that comes up very frequently. And this varies depending on what area of the state you live in and can matter even on a county by county or judge by judge level. So check with your local expert. Some counties treat student loan almost exactly the same as any other debt. Other counties are going to treat it more like a special debt that gets special status. And the circumstances always dictate, right? Even if I was in a county where student loans were treated like any other debt, and I kept getting married and divorced to cut my student loan debt in half over and over again, they're gonna see what's going. They're not gonna actually let you get away with that, right? Otherwise, that's what people would be doing as soon as they graduate medical school. Um, so it depends on the circumstances. You've been married for a year. I don't know that it matters what the student loan debt situation is. They're going to have the person who incurred it take that debt with them. If you've been married for 50 years, I almost don't, I don't, it's the opposite. I think it doesn't matter. The person, it's going to be divided or it's going to be taken into account.
What happens in a situation with bankruptcy? What if you have a huge amount of debt, right? You guys are looking at a divorce situation. We're talking north of $25,000, $30,000 of unsecured debt, like credit card debts and personal loans and such. When does bankruptcy become something that you're encouraging parties to consider?
Yeah, so and I'm not a bankruptcy attorney, so I'm usually looking at it. I have some knowledge of bankruptcy, but I'm certainly not an expert. So I'm going to look at your finances, and if you're sufficiently underwater, we're going to look at, hey, should you be meeting with a bankruptcy attorney to evaluate your options here? And that could be before the divorce or after. There's a benefit to doing it before. If the two of you go and do it together, you basically get your bankruptcy attorney half off because it's the same price. It's one bankruptcy for one married couple, or you each have one after the divorce. So doing it before the divorce has a benefit. Plus, then your finances are kind of wrapped up in a nice bow when you start that new chapter. You don't finish your divorce and like, great, now I got to start this bankruptcy process.
You had mentioned in another episode regarding debt that was really helpful when we were talking about common types of debt that we see in divorce settings. You mentioned taxes, and I feel like taxes is a worthwhile discussion again here today because it's one of those situations where that creditor is going to get paid, right? Like this is
Mm-hmm.
not features that might turn a
They
blind
don't go
eye
away.
spouse. Like the IRS, the Department of Revenue, they're not going away. So talk to me about how if you have a joint tax debt post divorce, what the implications of that can be.
Yeah, it's similar to so post divorce. It's similar to any other debt where the creditor does not care what the paperwork says. The paperwork from your divorce, because the paperwork from the debt says you're responsible, and the IRS will has, I mean, more authority than anybody else when it comes to garnishing your bank accounts, freezing your accounts, issuing levies, things like that. You have some options in terms of innocent spouse defenses if you're not the one who had anything to do with this, like married people who live totally separately. There are options with that, and you talk to a tax attorney about those options. But it's a sore subject, especially for people where there's where there's businesses, and the business owner hasn't been paying the taxes, and now there's divorces here, and now there's a big tax bill that we didn't know about before, and sometimes that's 60, 70, $100,000 in tax debt from not making payroll or things like that, or not withholding sufficient amounts. And when my client is on the losing end of that, it's a very difficult thing to even explain to them, but it happens.
Is there any sort of best practice, like when you're, let's say, starting a divorce case and the client says, yeah, there's some debts out there, they're in my spouse's name, and I don't really know, like I'm not sure what's that, like how do you make sure that you're covering all the debts out there if your client is maybe saying they're not even sure about it?
I would run a credit report right away, get like more. I always say more information is usually a good thing, and in this case, it definitely is. When you get the report, you can get it for free, by the way, from any of the three credit houses or from third parties like Credit Karma. When you get the report, don't panic. There may be debts on there that you didn't know about. There may be old debts that you thought were taken care of. If they were paid off or settled in some way, then you can deal with that. If you have old debts that aren't paid off, but you haven't, they're from 10 years ago, it's a medical debt. I mean, it's not just by you knowing about it doesn't mean that all of a sudden that debt's likely to be getting active collection efforts. But it's good to know about it so that you have a realistic view of what your current financial situation is.
How can you truly protect yourself? You're going through a divorce, you're putting together a settlement, and you want to avoid having to have a risk of your ex-spouse's creditors coming to collect from you when you really did nothing wrong and you were supposed to have not been responsible for that debt. What are the takeaways here?
The biggest way that people can get burned with this kind of thing is by lack of specificity in the agreement or poor drafting. So if you're doing like your divorce documents yourself, the pro se forms from the state, they leave a lot missing. Stuff that should be addressed isn't addressed in those documents. And that's really the problem that for post judgment issues, that's the lion's share of them. It's, well, the agreement that you two had at your divorce didn't say anything about what to do about an undisclosed debt. And so now we have to have an argument about that. If your lawyer knows, or if you take the time to write it, that this is a concern of yours, this is a priority of yours, then we can mitigate that risk. We can put in language that protects you and write it in such a way that that you have those protections not just written out, but also remedies in place, even like that are pre-agreed. If this happens, if you miss this payment, if I get a negative collections action against me, this is what happens to you as a result. And that can be a really nice incentive to make sure someone complies as well. So letting your lawyer know exactly what your concerns are, being highly communicative in that way, big help.
That's great advice. Yeah. So, I mean, I think a lot of people aren't spending enough time thinking about that. They're thinking about the assets they're going to get, if they're staying in the house, if they're getting certain retirement accounts, what the child support number is, but really thinking long and hard about how are the debts going to get paid? What happens if they don't? What are my risks, and how can I make sure that I am avoiding as many of those risks as I possibly can? And your advice is have a good plan, have a detailed plan, know what the recourse and the remedies are in the event somebody fails to pay, because we can't control the creditors, but we can control the recourse and the remedies available to our clients. So if that means they have to come back to family court, so be it. At least there's something there for them in the event one of the parties doesn't do what they're supposed to. So this was excellent, Jeff. As always, thank you so much
My
for
pleasure.
your detailed expertise. Thank
Thanks,
you.
Allie.
Yep.
And since so many of these problems come down to unclear debt division in the first place, it's critical to understand how Wisconsin law actually handles that, especially because debt, just like assets, is presumed to be shared equally, even if one spouse didn't rack it up. In the next episode, we dig into how that all works and why it often surprises people. Click here to watch.